Hi, this is Lee Phillips. I'm an attorney. Don't hold that against me. I want to talk to you for 2 seconds about charging orders. They're a form of asset protection. They're basically the reverse of the corporation or the corporate shield. That protects you from what happens in the company. The charging order protects the company assets from what happens to you. I need to give you a little history lesson first. 400 years ago in England, the only type of business structure that we had was a partnership. So you and I, we build this partnership and we build it for 30 years and it's a great company. And then I get in trouble. And how do you get in trouble 400 years ago in England? I don't know. You don't pay your taxes, you hit the guy with your horse and carriage, you get divorced, get sick, I don't know. But you got in trouble. I got in trouble. And I lose my assets. One of my assets is my partnership interest in our company. Well, when I lose my assets to my creditor, that guy comes in and he stands in my place. He's a partner with you. You just got a new partner. You got my ex as your new partner. And the funny thing is, in a partnership, the partner, any one of the partners, they can sell the assets of the company, they can bind the company, they can do anything they want. You just lost your company is the bottom line. That's not fair. I mean, you worked 30 years, you didn't get in trouble, and you just lost your company. And the Brits said, well, that's not fair. So they said, okay, what we're going to do is we're going to create a law so that when Phillips loses his partnership interest in this deal, the guy who gets it, his creditor, can't come in and stand as a full partner. He has to get the judgment against me. Then he has to go back to court and get an order which charges my partnership interest with his debt. But he can't come in, he can't walk in, manage the company. You're still a manager. You get to control what happens. He can't sell the company, he can't sell the assets of the company, he can't bind the company. All he can do is get this charging order, charge the company with the debt, which means if the partnership has a profit, he gets my piece of the profit. If it has a loss, he gets my piece of the loss. And so he stands in what we call my economic shoes, but he doesn't have management control. That's a big deal. Let's take it back to current day. Okay, you and I have our corporation. I get in trouble. The guy's going to come in, he's going to take my assets. My assets in the corporation, S Corp, C Corp, doesn't matter, is the stock. So he gets my stock. He's now a full voting member with you. If I happen to own a majority of this company, he now owns the company. If you're the only owner and you get in trouble personally, they just got your company. If, however, it's a limited partnership or an LLC, and you're going to use an LLC, then they have to go to court, get the judgment, and then get the order charging the company. They can't come and get the assets of the company and all of that sort of stuff. There are some wrinkles in the law on this, particularly in Utah, Colorado, and Florida right now. But basically, he can't come and get the company assets. You still manage the company. You can take all the profit. And the funny thing is you're going to figure out how to take all the profit. So it becomes a very good asset protection tool because this guy is now in a position where he can't really get to the company money or assets. And you go to him and say, you know, you can't really get to the company money or assets. Why don't we settle this for a dime on the dollar? That's good asset protection, guys. The charging order is critical. Corporations don't have it. LLCs, limited partnerships do have it. And your attorneys never talk to you about it.